Is it good?
Oh,
okay.
There we go.
That was so.
There we go.
Okay.
Hey, now we have sound. Welcome to the Senate Labor Committee, Senator Mohamed. We really are looking forward to hearing your bill, and we'll go ahead and if we know that we are missing some of our members at this point, but we've all had a very busy day at the Senate, and we know that people are making their way over here. So what we'd like to do in the goal of respecting everybody's time and energies this evening coming for this special session is to go ahead and get started with the presentation of the bill and the testimony to honor everyone's time. So with that, we'll go ahead and get started, and then our members will make their way here.
Great.
Welcome.
Thank you, Chair McEwen and members of the committee. It is wonderful to be here with all of you this evening, and I am so excited to present Senate File 2476, which creates a new minimum labor standard in Chapter 181 that protects employees' freedom of conscience by prohibiting employers from forcing employees to attend political or religious meetings or to listen to religious or political speech. This includes captive audience meetings for the purpose of communicating the employer's views about whether the employee should or should not join a union or be engaged in collective bargaining. Now, to walk through the bill, Subdivision 1 prohibits employers from disciplining, firing, or otherwise retaliating against an employee for refusing to attend employer-sponsored meetings, listen to speech, or view communication primarily intended to convey the employer's opinion about political or religious matters. Subdivision 2 allows employees to bring a civil action in district court against an employer who violates this section within 90 days of the alleged violation. The court may award the employee injunctive relief, reinstatement, payback, reestablishment of benefits, and any other relief deemed necessary to make the employee whole, including reasonable attorney fees. Subdivision 4 requires employees to post a notice of employee rights under this section within 30 days of enactment. And Subdivision 4 makes clear that this section does not prohibit employers from discussing workplace issues, does not prohibit employers from asking or inviting employees to religious or political meetings or to communicate about religious or political matters as long as employee participation is wholly voluntary, and does not prohibit an employer from communicating information to employees that is necessary for employees to perform their job. Subdivision 5 provides definition of political matters and religious matters. And with that, Chair, I will turn over to my testifiers. Thank you.
Very good. Thank you, Senator Mohamed. And if you could please introduce yourself or the testifiers as part of the presentation of the bill for the record. And then we will look forward to hearing your testimony.
Hi there, I'm Bernie Burnham, and I am the president of the Minnesota AFL-CIO. Thank you, Senator McEwen or Chair McEwen and senators for hearing us tonight. As I said, my name is Bernie Burnham, and I'm the president of the Minnesota AFL-CIO, the labor movement's shared voice of more than 300,000 working people who belong to more than 1,000 local unions in every corner of our state. In America, we value our many freedoms and constitutional rights. We value the freedom to hold our own religious and political views so much it's the First Amendment of our Constitution. Even when we're on the job, we expect a degree of those freedoms to extend to the workplace. That's why the Minnesota AFL is proud to support Senate File 2476 to protect those freedoms at work. With the recent surge of union organizing drives in Minnesota and across the nation, we've also seen the rise in employers holding mandatory meetings for the sole purpose of dissuading workers from exercising their legal right to form a union. These meetings have nothing to do with the actual jobs that workers do for an employer. In fact, many workers describe them as raw intimidation. These meetings often create a chilling effect that in many cases dooms the organizing effect, even when a significant majority of workers have signed union authorization cards to trigger an election. When Minnesotans go to work, we expect to do the jobs we were hired to do, and for any mandatory meetings to focus on that work. We don't expect to be forced to attend meetings against our will that promote a particular religious or political agenda or listen to veiled threats about exercising our legal right to organize. Freedom of conscience is a principle that Americans across the political spectrum value, and that freedom should extend to the workplace. Working Minnesotans urge you to protect that freedom by passing Senate File 2476. Thank you.
Thank you for your testimony. And next on our list of testifiers, we have Nate Kranz. Welcome to the Senate Labor Committee. If you would introduce yourself and any affiliation for the record, we look forward to hearing your testimony.
My name is Nate Krantz. I am here with SEIU, Healthcare Minnesota, and Iowa. And I guess I should start by saying I come from a union family. My father was a lifelong IBEW member, and a lot of my other family members have been strong union supporters as well. So it should go without saying that I would support my coworkers whenever they choose to unionize. Just no questions asked. But I worked as a nurse aide for about a year and a half in a nursing home, a CNA. And at the last place I worked, my workers chose to form a union or to ask for a union to be formed. And this was something management was clearly opposed to. In fact, they called us into regular meetings to remind us of that fact. Management's opposition to their workers forming a union can be broken down into three categories: a refusal to bargain, a complaint about democracy, or just a flat-out lie. At one point, they told us that the union could force you to go on strike, which is contrary to labor law in general, but that didn't really stop them. I was privileged to hear any number of those three on a daily basis, and especially on a daily basis when it came closer to the election. Management would couch their language in the fact that the workers had a choice, but insisted that it was the wrong choice. I know why I support forming a union, and I know what management was insisting was false and disingenuous. Regardless, I noticed that my heart rate tracker on my iPhone would spike every time I was forced to sit through one of these meetings. It would last the entire hour of the meeting. I remember the coworkers who were very proud supporters would not wear a pin in front of management because they were afraid of the attention it would get them. They did not want the added attention. The fact of the matter is that to disagree with your boss is a radical act. To say no to them is scary. They're the ones who decide whether or not you get a paycheck next week. And of course, you'll be afraid to take a position contrary to theirs. The workers know this, and management knows this. Union elections are meant to be decisions made by workers free of interference from management. But the constant drumbeat of anti-union speech directed through official company meetings, while not being explicitly directives, carry the same weight. Management knows this, and this is why they do this, and this is why I urge all of you to support this bill. Thank you.
Thank you for your testimony. Next on our list, we have Kip Hedges. Welcome to the Senate Labor Committee. If you would please state your name and any affiliation that you would like us to note for the record. We look forward to your testimony.
My name is Kip Hedges. I'm a retired machinist and also a retired Teamster. I was also a 28-year baggage handler for Northwest Airlines and then Delta Airlines. I was fired by Delta for union organizing, and their overreach and the blatant nature of my firing was such that, unlike many workers, I was able to force the company to give me my job back. The Machinists Union made it clear that they were going to back me all the way, and the company decided to make me be unfired. I decided to move on at that time because I did not want to work for a company that after 3 decades of building the airline would treat me in such a way for simply being for a union. Being a union organizer on the floor from the inside as an employee is a very difficult thing. Every day, as what happened to me proves, you might lose your job by the end of the day and then have to go home and tell your wife or husband or partner that you had lost your job because you stood up for what you believed. The company has a lot of tools that they use. They have anti-union law firms that help them sharpen up their anti-union campaigns. They have lawyers that help them stay just on this side of the law or just on this side of the law, or sometimes, as in my case, way over on this side of the law. They use social media, flyers, a constant TV loop, for example, at Delta Airlines at this very moment, because we're back in high gear to organize Delta baggage handlers. TV loop that repeats itself with anti-union messages happening right now at the airport. There's a bombardment. There are not captive audience meetings, because I believe Delta would say, we don't force anybody to go to those, but if you're not there, it's a problem, and they make it pretty clear it's a problem. So what we're really talking about, what I'm talking about, what I'm asking you to do is to take away one of those tools that the company has to suppress pro-union workers, to suppress the right of workers to have a voice. Just take away one of those tools so that we can level the playing field a little bit and have a little bit more of a chance for a voice and for dignity on the job. Thank you.
Thank you for your testimony. Next, we have Patrick Kennedy. Welcome to the Senate Labor Committee. If you would introduce yourself and any affiliation you'd like us to note for the record, we look forward to your testimony.
Thank you, Madam Chair and members. My name is Patrick Kennedy. I'm an LICSW and a therapist. I'm testifying in support of Senate File 2476.
Excuse me, sir, could you just have the microphone a little bit closer to your mouth? We just want to make sure we hear you loud and clear.
Is it
Thank
better?
you. That is better. Thank you.
Starting in 2016, I worked for 6 years at a nonprofit community mental health center called Headway, now called Uable Emotional Health. I held 4 different positions and served hundreds of clients. I felt really proud to work in community mental health and grateful to meet professionals like me who cared about 2 things: helping vulnerable people feel better and improving the field of mental health for the next generation of helpers. Whether it was the crushing caseloads or the low pay, about half the providers were quitting each year on average. This was discouraging for the staff and totally unfair to the clients. One colleague with a master's degree worked a second job to pay her bills, and another hadn't had a raise in 8 years. Managers told staff that the trick to longevity at the agency was to marry rich. When the pandemic started, we knew that management was not going to prioritize our well-being. In helping professions, we often say, you can't pour from an empty cup. I talked with colleagues about forming a union to make change within the system. With a union, we could use our firsthand experience in collaboration with management to improve conditions for staff and improve the care we offered our clients. By March 2021, with OPEIU Local 12, we were on track to form the first labor union in Minnesota at a community mental health center. By October, nearly 60% of the 130 eligible workers had publicly committed their support for a union. Before the election period, we were forced to attend a series of mandatory information sessions presented by the CEO and HR director. After months of intimidation and fear-mongering, this was their last attempt to break us down. In one meeting, we were told that wage increases were just about to roll out, but could be delayed another year if we unionized. In another, the CEO assured us that we would only harm our clients by forming a union. The effect on the vote count was shocking. 59 votes against forming a union, 55 in favor. In just a few weeks, union support dropped from 60% to 42%. A few months later, a colleague confronted the CEO at a town hall meeting, saying, "I made a mistake by voting against the union. I still haven't seen any of the changes you promised." As a social worker, I have a responsibility to challenge oppressive power structures. Employers use mandatory meetings to unfairly influence workers. If the meetings didn't influence workers, they wouldn't be happening. We have a legally protected right to choose whether to join a union, and we should also have a legally protected right to choose whether to listen to someone else's opinion, even if it's the person who signs our paychecks. Thank you.
Thank you for your testimony. Next, we have Kali Jama. Welcome to the Senate Labor Committee. If you would please introduce yourself for the record and any affiliation you'd like us to note, we look forward to your testimony.
I appreciate it. Thank you for having me here. My name is Kali Jama. I work at Amazon as my second job. The reason I'm here, and I'm a big supporter of this bill, it's working at Amazon right now, fighting them with the safety, the workers' rights. A lot of people don't know their rights. You know, coming to the United States as an immigrant, I always fought for our rights. I was the first Somali generation here. We always fought. So fighting in Amazon, what I realized is Amazon have union busters that will go put fear on people who don't understand their rights and laws. And I am here to ask you guys to help us in a way where we can have our rights without fearing and choose what we want to be without getting fired or terminated or just getting that fear of losing your job. So it is really important to me and my coworkers, some of them couldn't be here today, to pass this bill because I feel like if we do win, we want to be able to be unionized. But since Amazon have so many union busters, we cannot. And some of my people, they fear to lose their job because they have family members and people who they take care of. They can't afford to lose their work. So that's why I'm here today and I'm big on this bill. Thank you.
Thank you for your testimony. Next, we have Travis Lohman. Good evening, Mr. Lohman. Welcome to the Senate Labor Committee. If you would please just state your name and any affiliation for the record. And I have a note here that perhaps you're reading a letter on behalf of someone as well. So if you could just note the names for the record, we'd appreciate that. Thank you.
Well, thank you, Chair McEwen and the rest of the committee. First thing I'd like to do is I'd like to recognize the steelworker delegation in the room. We've got members from healthcare, members from paper, and we have some miners in the room. Well, as you mentioned, Chair McEwen, I'm going to be reading a letter actually from one of the miners on the Iron Range, a man named Dave Smith from Local 2660 at the Keetac Iron Ore Mine. My name is Dave Smith. I'm a member of the United Steelworkers Local 2660 at Keetac Iron Ore Operations. Years ago when I was fresh out of the Army, I took a job as a mechanic with a local contractor who did maintenance work on power lines. The company had just been purchased by the local electric cooperative whose workers were represented by a union. Many of my coworkers thought that we would be joining the union after the purchase, and I had hopes that this would bring union wages and benefits to my young family. It wasn't long before one of my coworkers came around with union cards for us to sign, but the company found out about it quickly, and we realized that they weren't going to quietly let us join the union. They quickly fired the worker with the union cards for an unrelated infraction, and management told us why they thought we didn't need a union. After that, talk of joining the union went silent. I think everyone was just too afraid of losing their jobs. A couple years went by, and working conditions went downhill. People were forced to drive trucks and equipment across the state to the Dakotas and Wisconsin without pay. Safety was lax, workers were getting hurt regularly, management was always pushing for faster production. A few of us had had enough. We contacted the Minnesota AFL-CIO for help. They put us in touch with an organizing team from the Laborers International Union. Over the next few months, the laborers organizers went door to door, getting more than 90% of us to sign union cards, and helped us choose our coworkers who would lead the effort to organize. We decided to help the company to voluntarily recognize the laborers as our union. We did this by appealing directly to the company's owner, the electric cooperative, at their monthly board meeting. Several members of the board were visibly unhappy that we had come to their meeting to surprise them with our request. They quickly denied our request and ushered us out. We soon learned that the company had hired a union buster, and we were all required to come into the company headquarters from our jobs across the upper Midwest to attend a mandatory meeting. At the meeting, several of the electric cooperative's board members were present, and they told us about why we didn't need a union coming between us. They forced us to watch videos about how labor unions were corrupt and tied to organized crime. The videos told us about how the union was going to charge us big initiation fees and monthly dues. They told us about how union bosses would steal our money and how unions make companies go bankrupt. We were forced to listen to the retired lawyers and accountants from the cooperative's board tell us all the reasons we shouldn't vote for the union. The meetings continued regularly while the union filed to have an election with a National Labor Relations Board. The NLRB held an election and we won by a landslide. We were finally going to get our union. We sat down with the company to negotiate our first contract, but things didn't go smoothly. The company stalled and made things difficult for the next year. They targeted workers who were leaders in supporting the union with discipline for made-up infractions. The union filed unfair labor practice charges against the company for this, and we continued to negotiate until 1 year passed after the election. The company then got a worker to file for a petition with the NLRB to decertify our union. Then the mandatory meetings started again. This time they worked. The company won. After more than 3 years of trying to gain a voice at work and not moving forward, workers believed all the lies that they were forced to listen to over the years. As I look back on my experience trying to stand together with my coworkers to gain a voice at work, I know that other workers are facing the same challenges that we faced. I know workers are forced to attend captive audience meetings while workers are left to try organizing in secrecy for fear of losing their jobs. I strongly urge you to pass this bill and level the playing field for workers in Minnesota. Thank you.
Thank you very much for sharing that testimony. Next, we have Michaela Arellano or Ariano.
Hi.
I apologize if I mispronounce your last name. Welcome to the Senate Labor Committee. If you'd please introduce yourself and any affiliation you'd like us to note, we look forward to your testimony.
Yes. My name is Michaela Ariano. I'm with CWA. I'm a licensed professional clinical counselor and licensed alcohol and drug counselor. I've been employed by mHealth Fairview for almost 6 years now, the past 3 years of which were on the inpatient detox unit. A couple of years ago, I became involved in a campaign to unionize as Professionals United for Safety and Health. We're a division of SEIU with joint membership to CWA. After going public with our filing in the end of December 2022, we were subject to numerous tactics by our employer to try and divide our united group and scare our colleagues. As an open committee member, I expected and experienced hostile management and retaliation. But the captive audience meetings, which were billed as programming meetings, is where this was turned on every employee in our unit right before the vote. The 2 HR staff that were present and the 3 managers present all had clearly defined roles. Some were good cops, others were bad cops. Of course, they spread lies and misinformation about dues and contracts. But the real reason that they had these meetings was for the intimidation effect. They wanted all the employees present to know that they were watching us and that they did not like what we were doing by trying to exercise our right to unionize. And when your employer ultimately has the power over whether you can pay your mortgage or have health insurance that month, their opinion of you, is as baseless as it may be, is going to have an effect on you. Even if our committee had had time to dispel every lie from those meetings, we couldn't undo the chilling effect that occurred. Our colleagues were less willing to associate with us, and they were more fearful of our union efforts. We had to spend a lot of energy in those last couple of days working to overcome that intimidation. Thankfully, our vote went through and we won by an overwhelming majority, but not without undue stress from this whole experience. My experience is why I support and I encourage your support of Senate Bill 2476. Thank you.
Thank you for your testimony. Next, we have Liddell Robert. Welcome to the Senate Labor Committee. If you would please introduce yourself. We look forward to your testimony.
Thank you, Madam Chair, and to the committee. I thank you for allowing me to speak here today. My name is Liddell Roberts. I'm with Teamsters Local 120. I strongly believe that captive audience meetings are anti-union meetings by companies are harmful and must be stopped. These meetings are clearly designed and to discourage employees from joining or supporting a union by presenting a one-sided biased view of the union and its activities. These are often mandatory, requiring employees to attend and listen to the company's anti-union message. Regardless of their personal belief, these meetings are a clear violation of workers' rights and freedom to organize. The right to form and join a union is a fundamental right for all workers. And companies that try to interfere with this right are acting in an unethical and immorally, these are also unfair to workers, who are often put in a position where they have to choose between their jobs and their right to join a union. Many workers are afraid to speak out against the company, anti-union messages. For fear of retaliation, this creates a climate of fear and intimidation that is designed and has an effect on a worker's ability to exercise their right. We all know that fear is false evidence appearing to be real, and we ask you to stand with us and fight for us to have the right to have a union if we choose so in Minnesota.
Thank you.
Thank you for your testimony. Next on our list, we have a couple of people who are on Zoom who've joined us online to testify. One of those people, it looks like perhaps it's not on the Zoom. I don't know if they decided to come in person instead. It's David, excuse me if I butcher this name, Gucci? Okay. If you are there on Zoom, let us know. Otherwise, we'll go on to the next testifier, which is Rachel Beaver-Scott.
Hello, everybody. Can you hear me?
Yes, thank you. We can see you and we can hear you very well. Welcome to the Senate Labor Committee. We look forward to hearing your testimony.
Well, thank you, Chair McEwen and the committee for the opportunity to speak on behalf of myself and my coworkers. As you know, my name is Rachel Beaver-Scott. I work at Half Price Books. I work at one of 4 unionized stores in the Twin Cities area. We're spread between UFCW locales 663 and 1189. We unionized just a little, or we won our election just a little bit over a year ago. So captive audience meetings are still very fresh in our memory. After we filed cards for an election, our first rounds of meetings were with a labor consultant from a large firm that refused to identify themselves to us, but had obvious access to our personnel files and would casually walk the sales floor, surveilling us between captive audience meetings. With her, I had several. The second set of meetings were with the HR rep and the company's in-house counsel. So employee versus HR rep and lawyer. And last, those sets of meetings were with our company's president, vice president, and our regional manager. Usually, against an employee or 2 at a time. So all these people above us with so much power over our employment, were trying to determine one thing from us, our vote. The threat there is implied. And once the threat is implied, the damage has already been done, regardless of whether or not the company faces any repercussions. We were the first of several stores to unionize. They've gone on in other states to unionize as well, and our company has ramped up efforts since then. And I know it's working because you see that divide between yes and no grow. And I believe that if we had cut it off at the legs here while it was in Minnesota, those employees wouldn't be in the same place they are now. Thank you.
Thank you very much for your testimony. With that concludes the list, unless the other testifier is here. I don't see anybody raising their hand, though. That, I believe, concludes the list of the people who had signed up to testify. Senator Mohamed, are there any other testifiers that you're aware of?
No, I think that was it. Thank you, Senator
Okay.
McEwen.
Very good. Well, with that, I'm going to open it up to discussion to the members. Would you like to say any words, Senator, before we do that?
Yeah, I think these folks' stories speak for themselves, and we have, I think we've seen what's happening across the country, and especially here in Minnesota. My district is no new to this. We have the Starbucks in my district, and these folks have been looking, begging, and have been doing this work in their own, shop to organize, and they've been facing some hurdles, and so that's kind of why I took on this bill. I think we have an opportunity to protect workers across the state. And so thank you.
Thank you, Senator. Members, discussion. Yes, Senator Umer Verbatim.
Thank you, Madam Chair. First, I just wanted to say how excited I am to see organized labor in the room. We have to keep our decorum here, so we're not clapping, but we sometimes do these hands just to show our excitement. Thank you all for being here and for all the work that you do and for sharing your stories. I remember seeing a John Oliver segment on union busting and those captive audience meetings that folks are forced to sit in on. Truly awful, and thank you for bringing forward the bill, Senator Mohamed.
Thank you, Senator. Yes, Senator Liskey.
Thank you, Madam Chair. Madam Chair, first I'd like to start with that I don't generally have a stance on unions. In fact, I'm in support of when they protect their workers. A lot of times they are very well at making sure that the workplace is much safer. They do really well at helping workers find new jobs if there needs to be, things like that. I'm not a huge fan of heavy stances in politics, which is partly where some of that animosity may come from. But generally, I think some of this bill is actually talking about politics, which brings me into my questions and things like that. I said this bill goes a lot past the not allowing union messaging during employment. And so my concern is, why are we using the language of political matters instead of focusing on the labor discussions that are kind of listed in the definition of political matters?
Senator Mohamed, do you care to answer that question, or if you have any other testifiers who want to address it?
Thank you, Chair McEwen. Senator Liskey, I'll let my testifier, my expert, answer that question.
Is this on?
Yeah.
Okay.
Yes, we could hear you.
Hello, Madam Chair and members of the committee. My name is Melissa Heising. I'm the Legislative Director at Minnesota AFL-CIO. Senator Liskey, the reason for the political and religious definition is because these are core matters of an individual person's conscience. Mm-hmm. And whether or not to belong to a labor organization falls under that political definition. And so it makes sense to protect the rights of workers to be free from being forced to listen to others' speech on politics or religion.
Senator Liskey, any follow-up?
Yes, thank you, Madam Chair. So I'm in full support of the First Amendment. Obviously, that's what this is describing. I'm a big constitutional guy myself. I think supporting that. And yes, this, I think, just draws us further into defining the First Amendment, which is great. The other question that I do have that would follow up with that is there are employers that are directly related to government and political affiliations. A list would be, sorry, I don't like to draw a list, but you have government affairs, community relations, public affairs, lobbying related professions, and other industries that are directly related to the government. Those all have political messaging included. And will this, with the way this law is written, I would read it as it would limit or prohibit those types of businesses from continuing. Is there a way to kind of change this?
Senator Mohamed or Ms. Heising? Go ahead.
Madam Chair, Senator Liskey, that is a great question. I would point you to lines 2.15 through 2.17 in the bill. This section does not limit the rights of an employer or its agent, representative, or designee from communicating to its employees any information that is necessary for the employees to perform their lawfully required job duties.
Senator Liskey, follow up.
Thank you, Madam Chair. So, yeah, I read that, but my concern is still that in the first parts, it still would limit them from presenting, and if that somehow encroached upon unionization, are you saying that then, let's say lobbyists for some reason wanted to create a union, not that I think they will, but if they did, this would then in theory prohibit it and then also not prohibit it. Is that correct?
Senator
Chair
Mohamed?
McEwen, Senator Liskey, it does not. What it does is it makes it clear that if these things are happening in the workplace and the employer is wanting to do these things, that if the employee wanted to attend voluntarily, they can, but you cannot require them. I think that's the thing that it accomplishes, that it makes it voluntary. So if the employee I'm interested in attending these things, I'll go and attend it. And if I don't really want to hear what my employer thinks of particularly unionizing, right, like, then I don't have to attend and there's no consequence there.
Senator Liskey, any follow-up?
Thank you, Madam Chair. I appreciate that. That's what I'm trying to see is like, where do we have these problems? We can cross these issues, so I just wanted to kind of cover those things. Thanks.
Very good. Yes, Senator Wiesenberg.
Thank you, Madam Chair. So this bill would work towards what is best for the employee, correct?
Senator Mohamed?
Chair McEwen, Senator, that's correct.
Okay. Thank you, Madam Chair. And then I heard, so just to be clear that, you know, it's legally protected right to choose whether we want to be in a union or not, correct?
Senator Mohamed?
Chair McEwen, Senator, that's correct.
Okay, so thank you, Madam Chair. So then I guess my question, would you be opposed to someone that's currently working in a union to be free of the union and still keep their job within that job?
Senator Mohamed, if you would like to answer that, or perhaps if there's anyone else, yeah.
Madam Chair, Senator Wiesenberg, could you restate your question?
Senator
Would you-
Wiesenberg?
Yep,
Yeah,
thank you, Madam
if
Chair.
you would, thank you.
Would you be opposed to someone currently working in a union to be free of the union but still keep their job?
Yes.
That is their choice. Do you mean working as a union member, to be a choice whether to be a union member or not?
Okay, so you could, sorry, thank you, Madam Chair.
Go ahead, Senator.
So I just wanted to make sure, I guess, because I used to work in a union for the government, and I was basically forced out of my job because they didn't protect me. So, yeah, so I think if you want to be in a union, that's fine. I'm not saying you shouldn't be in a union, but there was a situation where I had left, I came back, I was allowed to leave because of a health reason. I came back, some of the union had switched, so I was in with years of experience, and now I'm teaching people with 3 weeks of experience and making, you know, $2.50 less an hour than they were, but I was forced to teach them their job, and I was told, well, you don't get a raise, so you can either keep doing this or leave, so I quit. So how is, you know, we need to work on protecting people that way. I don't know how we do that, but I guess if that's a situation, how are we going to work with people like myself that, you know, I was working for the Department of Natural Resources for years, and then I came back and was making less than people who were there a less amount of time, and that's not right. Thank you, Madam Chair.
Thank you, Senator
That was a
Wiesenberg.
statement and a question, maybe, I don't know, so.
And if you have any comment, Senator Mohamed or Ms. Heising?
Senator Wiesenberg, this bill protects employees' rights to choose whether or not they would like to join or form a union, and leaves it up to them as to whether they would like to listen to the employer's opinion on that matter.
Thank you, Madam
Follow-up,
Chair.
Senator?
Just one more thing.
Sure.
So I guess, let's say they join the union and they don't like it. Could they keep their job and not be in the union?
Senator or Ms. Heising?
Madam Chair, Senator Wiesenberg, that depends on depending on whether they're public or private sector, whether or not they're in a right-to-work state or not, which Minnesota is not. I hope that gets at your question.
Well, thank you, Madam.
Well, and it does seem that this is somewhat out of the scope of this
Well, no,
this
well, that's
particular bill, but
I
go
guess what I
ahead.
was getting at is it's a legally protected right. Thank you. Sorry, Madam Chair.
Sure.
It's a
Go ahead.
legally protected right to be in a union or not. So if you join a union and don't like it, the right should be protected that you don't have to be in the union but still keep your job, if that's what we just said, right? Thank
Okay,
you.
Thank you. If there's any response, feel free, but Senator?
Chair McEwen, Senator, I understand what you're saying, and I think it makes sense, and I think it's a fair point to say an individual should be able to join a union and leave it, and if they do, they should still keep their job. Am I understanding that correctly? And yeah, I understand, that makes sense to me. I think the thing that this bill gets at is like, for instance, you go to a workplace, folks are interested in unionizing, and then you have the bosses or the people at the top telling the employees, hey, come to this work training or work meeting, and the whole work meeting is about why you should not unionize, why unions are bad. And so then that makes the employees really afraid of doing the thing that they wanted to do because they were already getting harassed often by the people in the administration. So that's what it gets at. It's saying you have a right not only to form a union, but you have a right to not join, to not be forced to go to those meetings. And if you want to, you also have a right to go over there, but that's completely voluntary and you will not lose your job because of it. Is that helpful? Thank you.
Thank you. Good discussion. Senator Gruenhagen.
Oh, thank you, Madam Chair. Yeah, just a couple questions of clarification. It kind of goes along the same line as Senator Wiesenberg. My understanding is, and I was on the school board for 16 years, and and of course we had a union in our school, and everybody had to belong to the union. All the teachers did, and there were teachers that weren't comfortable with that, and they actually wanted to leave the union, and then there was a lot they couldn't, and then because of some of the positions the union took politically, whatever they might be. But then there was a lawsuit federally, and I don't know if it went to the U.S. Supreme Court or not, but it did affect all states, and they could opt out during a certain period of time from that union. So I don't favor intimidation actions by the employer either, but on the other hand, I do agree with the freedom of choice testimony that was stated. And to me, if somebody wants to leave a union and still have his job, he should be able to have the right to do that. And again, my mom, on her second marriage, she was married to a union agent, and he actually worked for the AFL-CIO, and I saw through him sometimes, because I did attend with him on a few things, where people who didn't join the union got intimidated by union members to force them to join the union. And again, I think both things are wrong. I think you have to have the freedom of choice. But my understanding, and this is where I get to my question, it's only in a national right to work state that employees have that right to, let's say the vote was 70-30 to unionize, and that's fine. But the 30% all of a sudden didn't want to belong to that union, and my understanding is they would be forced to join the union anyway. Or am I understanding that incorrectly?
And I, just for the record, we have a whole body of federal law and unfair labor practices that could come into play in some of the situations that we've been hearing. But I do want to keep it to the scope of what this bill is really talking about. But with that, Senator Mohamed or Ms. Heising, if you have any comment or response to Senator Gruenhagen's comment, and please feel free to answer.
Madam Chair, Senator Gruenhagen, I believe you're referring to the Supreme Court's Janus decision, which made public sector open shop. This bill doesn't really interact with that. It just states that if you that your employee don't need to be forced to listen to your employer's opinions about whether or not you should join the union. And I would just want to note, too, that the employer, this bill prohibits employers from taking adverse action against an employee or threatening to take adverse action for declining to attend or participate in political or religious communications, such as an anti-union meeting. I forgot, I lost my train of thought there. So the employer is the entity here that has the power to discipline, fire, or take other adverse employment action against the worker.
Senator Grunhagen, follow up.
Oh, thank you, Madam Chair. Yeah, and I guess I'm weighing whether to, how to vote on this bill. And so, and maybe it's a little bit outside the scope of this bill, but if a group of employees vote to unionize, which they have every right to do, but you have 25% of the employees who don't want to belong to the union, are they forced to join the union under our current laws?
If you care to answer that, it is outside the scope of this bill, but if you care to, you may, yeah.
Thank you, Madam Chair. Senator Grunhagen, a majority vote or a majority of cards with voluntary recognition is what is required to form a union.
Senator Grunhagen, follow up?
So would all employees, even those who voted against it, have to join then?
Any follow up?
So, Madam Chair, Senator Grunhagen, and again, this is outside of the scope of this bill, but it would depend on whether you were in the public or private sector and what state you were in, and whether it was a right-to-work state.
Yeah, whether it was a right to, that's my understanding, yeah. Okay, thank you.
Thank you, Senator. Thank you. Members, any further discussion? Senator Marty?
Just, Madam Chair, just a comment that I think this is long overdue, so Senator Mohamed, thanks for bringing it.
On that note, I will also note that I have been in meetings like this with a former employer. I've also had family members who were forced to attend meetings like this with attorneys of employees. And yeah, it's very intimidating, and your livelihood is at stake. And even if it's there are situations where an employer can even sort of say that something is voluntary, but entice people to come with maybe pizza or whatnot, and then also punish people in various ways. And so I agree with Senator Marty that this is long overdue to make sure that employers are not allowed to retaliate against employees who decide that they aren't interested in coming to hear from the employer about their opinions about any of these matters. So thank you for bringing this bill, and thank you very much to all of the testifiers who have come to offer their testimony and their stories. And I believe Senator Grunhagen has one more thing. Yes, go ahead, Senator.
Oh, thank you, Madam Chair. Yeah, I guess if we were a right-to-work state, I'd vote for this bill. But since we're not, I'm afraid I'm going to vote no. So.
Yes, Senator Umar Verbaeten.
Thank you, Madam Chair. I'd like to move the bill, move that Senate File 2476 be recommended to pass and re-refer to the Judiciary Committee.
Thank you, Senator Umar Verbaeten. On Senators Umar Verbaeten's motion to approve Senate File 2476, all in favor, please say aye. Aye. Any opposed, say nay. The motion passes. Thank you very much, Senator Mohamed. And with that, the Senate Labor Committee is adjourned.